Hello, everybody. I'm Michael Scharf. I'm the co-dean of the law school, and it is my great privilege to welcome you to today's lecture. My sole function is just to welcome you to the lecture and to turn things over to the director of our Center for Business Law and Regulation, who has organized this event, and you're in for a really interesting event. Thanks for coming, and we'll look forward to seeing you at other events in the future. Over to you, John.
Great, thank you, Michael. It's a pleasure to be here today. Thank all of you for coming on what will be, I think, a really informative and provocative program on the Supreme Court's decision in Janus versus AFSCME and its implications for the future of public sector unions. It's really a pleasure today to be able to introduce to you the two speakers we have to talk with us about this subject, who present two very different perspectives on this question, but also two people who have been very involved in issues related to public sector unions and representation. To my immediate right, we have Robert Alt, who is the President and Chief Executive Officer of the Buckeye Institute, which filed an amicus brief in Janus versus AFSCME on behalf of Mr. Janus. He is a former director in the Center for Legal and Judicial Studies at the Heritage Foundation, a former adjunct here at the law school where he taught legislation as well as national security law, and clerked for Judge Alice Batchelder just a little bit down the road from us. To his right is Professor Marty Malin from the Chicago-Kent College of Law, where he is co-director of the Institute for Law and the Workplace. He too participated in an amicus brief in Janus versus AFSCME, supporting the unions in that case. He is a former national chair of the Labor Relations and Employment section of the Association of American Law Schools, a former secretary of the ABA section on labor and employment law, former member of the executive committee of the law group, and a former member of the board of governors of the National Academy of Arbitrators. And I think between the two of them, we will get a range of perspectives and insights on the Janus decision, and equally important, what it means going forward. I want to provide a little bit of background on the case, just for those of you that would like a refresher on the details, and then I will moderate a discussion with our panelists before we open it up to questions from all of you. So just a little bit of background. Janus versus AFSCME concerned question whether or not mandatory agency fees for public sector employees who do not wish to join or support their union are constitutional. For decades, there have been questions about when and under what circumstances governments may require actions that may be characterized as either compelled speech or compelled association. And there is a strain in the Supreme Court's First Amendment case law that suggests that in at least some circumstances, compelled financial support of certain sorts of organizations or messages may constitute a form of compelled speech that is subject to First Amendment scrutiny. In 1977, in a case called Abood versus Detroit Board of Education, the Supreme Court held that some portion of agency fees may be imposed on public sector employees, but some portion may not. What the court held was that public sector unions could collect mandatory agency fees insofar as those fees were used to pay for things that are associated with collective bargaining, representation of employees, and the like, but could not impose mandatory fees for things related to the union's political activities or things that might seem to impinge more directly on the rights of public sector employees not to support political messages that they do not support. And that, somewhat of what we might think of as a compromise position, had been the law for several decades. In the past decade or so, that compromise had come under fire, and the Supreme Court heard a series of cases that narrowed or questioned some of the underpinnings of the Abood decision. Particularly recently, in a case called Friedrichs versus California Teachers Association, the court had split 4-4 over whether or not to overturn Abood. The ninth vote in that case would have been cast by Justice Antonin Scalia, who died before the court was able to reach its decision. So this past term, the court reconsidered the question of whether or not mandatory agency fees at all are constitutional under the First Amendment, and the court, in a 5-4 decision, overturned Abood and held that mandatory agency fees are not constitutional, that they represent a form of compelled speech and association that violates the First Amendment rights of public sector employees who do not wish to support or be members of their union. The court concluded that in the public sector, even issues that are associated with collective bargaining and the cost of representation have a political component because they necessarily relate to things like how government agencies allocate their budgets, what sorts of revenues and spending the government must engage in. And so the distinction between political and non-political activities, the court did not think was as viable here as it might be in the private sector context. And the court went on, in the opinion by Justice Alito, to argue that the various justifications for compelling assessments or mandating agency fees were not sufficient enough to survive the heightened scrutiny that is required when the government compels speech under the First Amendment. As I mentioned, the court was a 5-4 decision. It's a controversial decision and one that we are still considering and what the potential implications will be. So with that background, I'd like to turn to our panelists, and I'll start with you, Robert. As I noted before, Buckeye filed an amicus brief in support of Janus. I assume that means that you think the court got Janus correct. And I was wondering if you could just give us your initial assessment of this decision and why you think the court was correct to hold the way it did.
Well, yes, I do think they got it correct, and I think really they did so for the reasons that were sort of toward the tail end of your description. The fact that Abood had attempted to strike a balance, finding that in fact you could not be compelled to contribute to support speech that was political in nature, but that ended up being a distinction that didn't hold up in application with regard to collective bargaining in the public sector. That fundamentally, collective bargaining in the public sector looks a lot like lobbying. It looks a lot like questions of political concern, and that even leaves to a side activities that I think we would probably all agree would cross the line into political activity. So for instance, if you take a look at the public disclosures that the unions filed, even in the year leading up to the Janus decision, many of the big national unions went ahead and paid for their conventions using, for instance, fair share fees as part of that, the funds that paid for the conventions. At their conventions, they endorsed political candidates, took positions on everything from immigration, climate change, marijuana legalization, the metric system, advocacy for public funding for Planned Parenthood, things that no one would dispute are fundamentally political in nature, particularly endorsing political candidates, passing resolutions that they would do everything within their power and mobilize millions of individuals to vote for those particular candidates. But let's look at issues a little closer to home. Here in Ohio, I think if you take a look at a number of the collective bargaining agreements that are entered into, one of the most important things to keep in mind with regard to whether or not they're political is this little device here. Now in the age in which we no longer have payphones, quarters may seem irrelevant, but this ends up being a powerful decision-making tool under collective bargaining agreements at many schools, where the question of, for instance, layoffs in cases of times of fiscal crisis are required under collective bargaining agreements negotiated by the unions to be determined only by seniority. But what happens if there is a tie in seniority between, let's say, the teacher of the year and the lowest performing teacher in the school? If you are a teacher in Westerville or Marietta, Ohio, the union bargaining agreement dictates that decision must be made by a flip of the coin. These are fundamentally questions of public concern that many people actually take differing views on, teachers, people in the community, and it goes to the fact that the contents of these collective bargaining agreements, when they involve public sector employees, fundamentally raise political questions that are inextricably intertwined with those policies. And then fundamentally, I think the Janus case recognized that in fact you could not separate out these questions, that these really were political questions, and that violated the First Amendment rights of workers like Mr. Janus, who took very different positions than his union with regard to, for instance, pension benefits and the potential impact it would have on the budget of Illinois, and whether or not it was a good thing for him or for the state as a whole.
Marty, you were on an academic brief taking a different view. What is your initial assessment of what the court did in Janus and why it was not correct to rule as it did?
Well, I found it horrifying, quite frankly, not surprisingly, to all of you on a number of levels. First, the total disregard of a 41-year-old precedent, Abood versus Detroit Board of Education, but not just a 41-year-old precedent, but a precedent that had been reaffirmed on at least 4 other occasions by the court. A precedent that had been applied in other contexts, such as holding that unified bar associations did not violate the First Amendment rights of attorneys in the state that had the unified bar association. And a precedent where the court had 3 previous times the opportunity to overrule it and had not overruled it. And what concerns me is if we contrast what the court said about stare decisis in Janus to what the court said about stare decisis in the other blockbuster labor and employment law decision of the 2017 term, and that was Epic Systems versus Lewis. So Epic Systems versus Lewis, the court resolved to split in the circuits over the National Labor Relations Board's view that when employers impose on employees as a term and condition of employment, that they waive their right to litigate via class actions or even by collective actions, even 2 employees joining together, and instead agree that they will arbitrate any claim on an individual basis. That contravened the employee's rights under Section 7 of the National Labor Relations Act to engage in concerted activity for mutual aid and protection. The same 5-4 majority in Janus decided Epic Systems and overruled the NLRB and the 7th and 9th circuits. And this is what the court said about its prior decisions under the Federal Arbitration Act. The court said in many cases over many years, this court has heard and rejected efforts to conjure conflicts between the Arbitration Act and other federal statutes. In fact, this court has rejected every such effort to date, with statutes ranging from the Sherman and Clayton Acts to the Age Discrimination and Employment Act, the Credit Repair Organizations Act, the Securities Act of 1933, Securities Exchange Act of 1934, and RICO. Throughout, we have made clear that even a statute's express provision for collective legal actions does not necessarily mean it precludes individual attempts at conciliation through arbitration. And we stress that the absence of any specific statutory discussion of arbitration of class actions is an important and telling clue that Congress has not displaced the Arbitration Act. And here's the key line. Given so much precedent pointing so strongly in one direction, we do not see how we might faithfully turn the other way here. Contrast that to what the court said about stare decisis in Janus. The court said, an important factor in determining whether a precedent should be overruled is the quality of reasoning, of its reasoning, and as we explained in Harris versus Quinn, Abood was poorly reasoned. That is, we disagree with Abood, so we're going to overrule it. And the court went on to elaborate why the court majority disagreed with the reasoning in Abood. Similarly, with respect to reliance on established law, the court poo-pooed the idea that parties relied on Abood and its progeny in Janus. The court said because public sector collective bargaining agreements are generally rather short duration, a great many of those now in effect probably began or renewed since Knox in 2012 or Harris in 2014. But even if an agreement antedates those decisions, the union was able to protect itself if an agency fee provision was essential to the overall bargain. And goes on to just say, we're not worried about parties' reliance on 41 years of law. Contrast that to the same court's decision in a case called Encino Motor Cars versus Navarro. Now that concerned a very technical issue under the Fair Labor Standards Act, whether the service advisor at your car dealership who writes you up when you bring your car in for service was a mechanic, partsman, or salesman, and therefore exempt from overtime under the Fair Labor Standards Act. Now, the Labor Department, for a considerable period of time, had issued opinion letters saying that exemption applied. But then the Labor Department issued a regulation going through the regular APA notice and comment rulemaking and reversed itself. And the regulation said it didn't apply. And this is what the court said in reversing the Ninth Circuit, which had upheld the DOL regulation. The court said, the retail automobile and truck dealership industry had relied since 1978 on the department's position that service advisors are exempt from the FLSA's overtime pay requirements. Dealerships and service advisors negotiated and structured their compensation plan against this background understanding. Requiring dealerships to adapt to the department's new position could necessitate systemic, significant changes to the dealership's compensation arrangements, and on about the dealership's reliance interest that the court just poo-pooed in Janus. Notwithstanding the fact that no dealership could have been held liable for any back unpaid overtime prior to the effective date of the regulation, because under the Fair Labor Standards Act, reliance on opinion letters by the Department of Labor is a defense to monetary liability. And of course, unless they were covered by collective bargaining agreements, in which case the reg was irrelevant anyway, those service advisors were terminable at will, so they could rewrite their compensation arrangements at will. I fail to see any consistency whatsoever. To me, Janus was a result-driven decision that's totally inconsistent with concerns of reliance on stability in law, with concerns of stare decisis, and I consider it the Mitch McConnell decision, because had there been a vote on President Obama's nominee, it had gone the other way.
And what is your view of the First Amendment, the underlying First Amendment question? Was the court correct in Abood, or was it simply this was the resolution the court had reached in Abood, and it's worked for 40 years and people have relied upon it, and stability, predictability, and reliance are important to maintain?
Well, and we may get into this with some of the later questions later, but I think a critical change that Janus brings is prior to Janus, there was a general recognition by the court that when the government acts as an employer, it's doing something different than when it acts as sovereign. And the court's approach to the government as an employer vis-a-vis the constitutional rights of its employees as employees has always been a utilitarian approach, and one which I personally agree with. I think Janus makes a huge change to that, and indeed will, and we may get into this later, result in changes to other aspects of the law governing the public-employee relationship that are now up for grabs. Indeed, a number of conservative law professors filed an amicus brief urging the court to reaffirm Abood precisely because of that concern.
Robert, do you have any thoughts on the broader implications for public sector employees? And there have been a bunch of cases in which the Supreme Court has been fairly solicitous of government entities as employers when, acting as an employer, the government entity has felt the need to constrain or discipline employee speech. And that, as Marty just mentioned, that principle might seem to be in tension with the Janus Court's solicitude for the speech interests of the public sector employee who does not want to be a member of a union.
Well, I think there were a couple of key distinctions they made which may end up being important in future cases. One of the things that the court really did emphasize was essential to its determination was this was not a question with regard to even limiting the particular speech. This was a question about compelling speech. And they did note that that was different in kind, comparing it to the Garcetti case. Leaving aside the question, in that particular case, they noted that in this particular case, an individual made a statement which was seen more private concern than public concern. And they noted that here the issues were fundamentally of public concern. But they noted that it would have been a very different case if, instead of trying to restrict speech, if in fact the employer had attempted to force speech and did so not in the course of their particular employment, but with regard to lobbying practices. That would have changed the outcome in the case in the court's mind, and I think that's correct, and may provide guidance. Once again, it's not without guardrails, and it's not without distinctions with regard to what was happening. I did want to put a quick note with regard to stare decisis and the determination and sort of looking at these. I think, as you're looking and comparing cases, there were a number tossed out there. There clearly is a difference between constitutional and statutory stare decisis, and in terms of that, and in particular, looking at the error costs associated with correction in a statutory context. And so, a couple of the cases I think that we're looking at were statutory or regulatory construct, as opposed to, in this particular case, the court is looking at the far more fundamental question as to whether or not they got the Constitution right. And their ability is to simply defer to Congress to fix the particular question. And, they don't necessarily always have that option. The court is actually forced at times to reconsider its previous decisions. And particularly in a case like Abood, where really, this was kind of an attempt to split the baby, to make sure that people weren't being compelled in the political context while trying to achieve some objective maintaining the agency fees. And they just found ultimately it not to be workable, consistent with the First Amendment.
So this is not the last suit challenging public sector unions. Robert, I think in fact Buckeye has a petition for certiorari pending now in a post-Janus case, is involved in some other post-Janus cases. Could you tell us a little bit about what those cases are, what they're about, what are the claims that you're, and then I'm going to ask Marty to assess those claims.
Sure. As of the time that we're sitting here, I'm aware of at least 50 cases that have been filed post-Janus that raise significant claims. I'll just sort of describe them generally in a few different buckets, just so that you have a sense of what all is potentially pending. So first of all, just to take a step back, the court in the Janus decision declared that unless employees clearly and affirmatively consent before any money is taken from them, the standard laid down by the court could not be met. And they further stated that to be effective, the waiver must be freely given and shown by clear and compelling evidence. Based upon this language, there's been a couple of cases, groups of cases that have been filed challenging the collection of agency fees, so-called clawback cases. Most unions that I'm aware of did go ahead in the immediate aftermath of the Janus case and took those individuals who were agency fee payers and went ahead and stopped collecting those agency fees immediately. But a number of unions actually took the position that the Janus decision only applied to agency fee payers. The AFL-CIO publicly stated, quote, "It is important to remember that the ruling will apply only to non-members. The court's decision has no application to members," end quote. And the General Counsel for the National Education Association, one of the nation's largest teachers union, declared similarly that Janus's decision, quote, "does not mean that unions have to resign existing members. Janus is about fee payers." So you've got one group of cases that look at the agency fee payers and agency fees that were paid prior to the Janus decision coming down. You've got a number of class action suits that have been filed across the country seeking back agency fees. There are other cases that have been brought on behalf of full union members, claiming that they did not adequately consent or there's not sufficient evidence of their consent. challenging, for instance, the union cards or the union's inability to produce cards demonstrating that the individuals did in fact consent as required by the courts. Others are challenging the opt-out windows. Unions in numerous states established windows during which an individual could opt out. Here in Ohio, we've got 3,200 collective bargaining agreements which govern the employment conditions of roughly 320,000 public sector employees. The opt-out windows are all over the map. You have some that were entered into just before the Janus decision was scheduled to come down that pushed out the opt-out window for years in the future until 2021 or 2022 would be the first available instance in which an individual would be able to exercise those particular rights. So based upon that, a number of public interest law firms have filed suit on behalf of union members. In most of those cases, the unions have chosen to settle almost immediately, not seeking to defend those provisions lest they actually get an adverse ruling. And then the cases that Buckeye, we've got, as Professor Adler mentioned, we've got a cert petition pending. We also have a couple of other cases pending in the courts of appeals. We have brought a challenge to the state requirement of exclusive representation. And here, in particular, we pointed to some very strong language in the Janus decision. The court twice noted that designating a union as the exclusive representative of non-members substantially restricts the non-members' rights, end quote. And the court referred to exclusive representation as, quote, a significant impingement on the associational freedoms that would not be tolerated in other contexts, end quote. In many ways, we see this as sort of the flip side of the Janus coin. Janus said you couldn't be compelled to pay for political speech with which you disagree. But under exclusive representation, these same individuals are forced to speak through the unions, whether they agree with the unions or not, and are prohibited, in fact, from speaking in an official sense on their own behalf. They can only speak through the union with regard to representation and in some cases with regard to grievance proceedings. One of my clients, Kathy Uradnik, to add insult to injury, the union in fact has taken positions which are adverse to non-members, something which should be impermissible, but they have done for years, prohibiting through the collective bargaining agreements non-members, in this case professors, from serving on various faculty panels, which are considered in, among other things, tenure decisions, promotion decisions. It also denies those individuals a say with regard to who becomes the dean, what the curricula is, new faculty hires, by virtue of the fact that they are simply not permitted to participate in those committees. Obviously, this is a position with which she disagrees, but she has no ability to actually advocate on her own behalf. She is forced to speak through the union, which speaks against her. And so it is on her behalf that we have filed a petition for review at the Supreme Court challenging exclusive representation.
Marty, what is your take on these suits? Does Janus lay the groundwork for these sorts of cases? Are they likely to succeed? And what sorts of consequences might they have?
So,
A lot there, but
yeah. Let me start with the last thing that Robert talked about, and that is the Buckeye Institute's actions, and there's also a right to work action where there's a Supreme Court cert petition pending to declare the principle of exclusive representation unconstitutional. I wonder if these organizations would be surprised to learn that they are in complete agreement, or large agreement with the International Union of Operating Engineers. International Union of Operating Engineers Local 150 has a lawsuit pending in U.S. District Court in Chicago seeking to have its duty to represent non-members who now don't pay anything declared unconstitutional. Saying it's compelled speech. We're being compelled to speak for these people who don't want to be part of us, and therefore it violates our First Amendment rights. So this is, I think what we're seeing is what those conservative law professors predicted, right? We're about to have a period of chaos. I don't understand how having the principle of exclusive representation declared unconstitutional assists your clients, Robert. Basically, there's two ways that a public employer will determine terms and conditions of employment, either setting them unilaterally or through collective bargaining. The idea that an individual who's not a member of the union, who's an employee of the city of Cleveland, is going to sit down, with the commissioner of personnel of the city of Cleveland and negotiate his or her own individual employment agreement is absurd. It's simply not going to happen. If you declare the principle of exclusive representation unconstitutional, unions will negotiate the collective bargaining agreement for their members, and then the employer will unilaterally apply that to everybody else. They're not going to negotiate one-on-one with all of these individuals. And so those non-members are going to be worse off, because what comes with the principle of exclusive representation is a duty to fairly represent every employee. And some of the provisions that Robert is talking about, I would say go challenge those as breaches of the duty of fair representation rather than as things that are unconstitutional. So if you end the principle of exclusive representation, they've got no recourse against the union, even though the union is going to be negotiating the terms that they're going to be bound by, because their employer is going to unilaterally impose it on them. The clawback lawsuits, there are tons of issues there. The first question is whether they get class action status. The Seventh Circuit, in the follow-up litigation to Harris versus Quinn, denied class action status on the ground that the plaintiffs failed to show, in accordance with Rule 23b3 of the Federal Rules of Civil Procedure, that there were common issues that predominated over individual issues, and that a class action would be a superior vehicle for resolving the claims, and did not reach the 23A issues. That decision was Riffey versus Rauner. The Supreme Court vacated that decision and remanded for reconsideration in light of Janus, and the Seventh Circuit said, we reaffirm our prior position that this does not qualify as a class action. Why? Because the motivation behind the individual claimants varies tremendously. Mark Janus is the exception. Now, I have served prior to Janus, under Chicago Teachers Union versus Hudson, the unions had to provide a vehicle whereby fee payers could challenge the determination of their fee, and the union had to prove that the fee was appropriate. And the American Arbitration Association accredited a panel of arbitrators with sufficient expertise, and if a union contracted with AAA would appoint an arbitrator. And the Supreme Court in Chicago Teachers Union versus Hudson approved that kind of procedure. So I've served as an arbitrator in numerous challenges to the amount of the fee, and have indeed cut a number of unions' fees in that capacity. Invariably, the challengers that show up are not the Mark Janus who have ideological objections to positions the union are taking, but are employees who believe the union is doing a terrible job, and therefore they don't want to support this union financially. That illustrates what led the Seventh Circuit in Riffey versus Rauner to deny class action status. That is, the interests of individual potential claimants are all over the board. They're not in common. I would suggest most of them, it's financial, it's not ideological. I agree with Robert. I think one of the major things to come out of Janus is this idea that it is that compelling speech, or more specifically, compelling financial subsidization of speech, is worse than repressing speech. And where is that going to lead us? Just the other day, and I don't have the site off the top of my head, There's a cert petition that was filed a while ago challenging a Court of Appeals decision upholding what has been, routine NLRB, National Labor Relations Board law concerning the wearing of union buttons. And this case involved employees wearing Fight for 15 buttons, and the employer prohibited them from wearing those buttons. They were not in public contact positions. The employer had no special circumstances to justify that. The NLRB said he violated the National Labor Relations Act. The Court of Appeals agreed. The employer petitioned for certiorari. The employer just filed a request to amend its cert petition or supplement its cert petition, claiming that under Janus, this is now compelled speech and is unconstitutional. Now, I suspect that is going nowhere because, it's an 11th hour amendment to something that was never raised below. And so I suspect it will be discarded on procedural grounds, but it illustrates the chaos that we're heading into, in part because of this notion that compelled subsidization of speech is somehow worse than oppression of speech.
Now, between the clawback suits and the loss of agency fees, this obviously creates challenges for public sector unions, financial challenges, perhaps as well as organizational challenges. Marty, I know you've done some thinking about how public sector unions can and perhaps should respond to this new legal environment. You mentioned the one suit that is, I guess, an aggressive posture that some unions might take of saying, if we can't collect fees to support what we do, well, then we can't be required to represent those that are not funding the collective enterprise. What other thoughts do you have about how public sector unions can and should respond to these new constraints on their finances and activities?
Well, it's not just a concern for public sector unions, it's a concern for public sector employers. And let me start with unions first, but then tie it into employers, if I may.
Sure.
So one of the other problems I have with the Janus decision was the court established a straw man and then knocked it down. The court claimed that the justification for agency fees was to prevent free riders. And that's not it. The justification for agency fees is that it is a solution to what economists refer to as a collective action problem. That is, even employees who support the union and who want to be represented by the union will not join the union unless they are assured that most of their coworkers will also join the union. And that's because their individual dues payment will have minimal effect by itself on the union's ability to represent the workforce and to garner the public goods. And so agency fees were designed to rectify, to deal with that problem, that collective action problem. And well, Justice Kagan recognized that in her dissent. The majority opinion by Justice Alito just is blind to the collective action problem. So the question is now, since agency fees are no longer permissive, how can you deal with the collective action problem? So Catherine Fisk from UC Berkeley and I have an article forthcoming in the California Law Review that suggests some ways. One way is to basically have benefits that are available to members only. And some of the things we've suggested, for example, and we see this with respect to protective service personnel. So firefighters don't have a collective action problem. Firefighters have close to 100% union membership, and they will continue to have close to 100% union membership. Why? Because no one's going to do a duty trade with someone who's not a union member. They're not going to allow people who are not union members to participate in their pool for groceries and and meals and the like. And they're in a small group in that fire station, and so there's And collective action problems are least likely to arise in small groups. So drawing on firefighters, we suggest what are some of the other things that unions that are not firefighter unions or police unions. Police unions don't have a collective action problem because cops join the union because one of the benefits they get is legal representation, which the union is not obligated to provide to non-members under its duty of fair representation. We have some of that in right-to-work states or teacher unions as well. So we've suggested things that the unions can negotiate, things like sick bank leaves that require coordination, and the union would coordinate it for all of the union members. The others, they could do the coordination on their own. We suggested recognizing that access to a grievance procedure in arbitration is a benefit of employment, just like health insurance. And thus the costs of the arbitration procedure itself, the arbitrator's fee, the hearing room rental, that those should be spread amongst the employees in the bargaining unit. And then the union can, as a benefit of membership, pay its members' share of those costs. Things of that sort. There have also been actions in a number of states have enacted statutes that require employers to allow the union to meet with new hires either at orientation or within typically 30 days of their new hire on the clock. Again, looking to create, to deal with the collective action problem at a small local level rather than, in a statewide bargaining unit of tens of thousands of employees. So those are some of the things that we've suggested out there. Some of it can be done through collective bargaining, some of it unions can do on their own, some of it requires legislation.
And then you said there were responses that legislatures might make or employers might make that might be
Oh,
more
yeah,
controversial.
so the other thing unions might do, and this is what I think public employers and the public in general should be concerned about. And that is, unions are forced to organize internally now to keep their members from leaving and to sign up new members. And one of the ways they will do that is by demonizing the employer. Sometimes it's not real hard to demonize the employer depending on who the employer is. So AFSCME claims that former Governor Bruce Rauner was its best organizer because every time Rauner opened his mouth and talked about employees, AFSCME signed up more members. And AFSCME claims it has signed up numerous prior fee payers as members since the Janus decision came down. The federal employee unions, National Treasury Employees Union and American Federation of Government Employees, say that Donald Trump is their best organizer. Because every time he does something, like issue an executive order freezing employee pay, they sign up new members. Well, one thing I think some unions are going to do is they're just going to demonize the employer as an organizing tool, instead of working cooperatively with the employer for the benefit not only of their members, but of the public. We have numerous examples where public services have been enhanced due to joint efforts of public employers and unions, and in both within the federal sector and within the state and local government sector. There have been several economists who have conducted studies that show the most effective and most efficient workplaces are high-performance unionized workplaces. And indeed, in the oral argument on Janus, David Franklin, the Solicitor General of Illinois, pushed this, that you put unions in a position where their financial security is threatened, where they may have to demonize the employer to do this internal organizing. This is a very huge threat to labor management cooperation, which is a concern to public employers and should be of concern to the public. Let me give you an example that, in my experience, is analogous of unintended consequences. So in 2011, the Illinois Education Labor Relations Act was amended only with respect to the Chicago public schools, and the statute's officially school districts serving populations of 1 million or more. And most public employees in Illinois have the right to strike. But employees of the Chicago public schools, for their strike to be lawful, it must be authorized by a vote of at least 75% of the entire union membership. Not 75% of the folks voting, but 75% of the entire membership. When that amendment was enacted, people were saying we will never have another teacher strike in Chicago. A year later, guess what? And what happened? The Chicago Teachers Union, to motivate its members to go out and vote to authorize a strike, totally demonized the Chicago Board of Education and the mayor of Chicago. Now, Rahm Emanuel helped them a lot with a lot of the things he did. And they got way more than, they got 89% of strike authorization vote. So they go out on strike, and over the weekend, they reach a deal. So they've been on strike for a week. They reach a deal, and they take it to the union's House of Delegates on Sunday. And the House of Delegates has to recommend the deal to the rank and file membership. Otherwise, under the union's bylaws, they could not end the strike. And what happens? The union had done such a good job of demonizing the mayor and the Chicago Board of Education that the union leadership could not sell the deal to the membership. And the union president had to end the meeting without taking a vote, telling everyone, go back to your schools. The House of Delegates is a delegate elected from each school. Read it over carefully, go back to your schools, talk to your members, and then we'll reconvene on Tuesday. Monday was Rosh Hashanah. And then cooler heads prevailed, and on Tuesday evening, they voted to recommend it, and then the strike ended on Wednesday morning, schools reopened. You know, I have concern that we'll have a similar kind of aggressive demonizing as an internal organizing and a good deal more militancy, and we'll all be worse for it.
I want to leave a little bit of time for questioning, so I'm just going to pose one more question to each of you, or that you each can respond to, and I'll start with Robert. Some have speculated the principle in Janus goes beyond unions, goes beyond the public sector, could affect things like, since we're lawyers, mandatory bar dues, insofar as you have unified bar associations that, in addition to playing the regulatory role, also engage in activities that might be characterized political or characterized as political. What about that? Is that the next domino to fall? Should we be worried about that?
There is some indication that Janus will have application to mandatory integrated bar fees. There was a challenge that was recently brought to the Supreme Court to, I believe it was North Dakota's.
Yeah, Fleck versus Welsh is the case.
Yeah, and there's actually been a second case that's filed, I think, out of Oregon as well. But the case out of North Dakota, the interesting thing in that case is there was a more narrow claim with regard to whether or not it was being operated properly. That had generally been a prohibition, once again, with regard to the fees being used to support political activities. But there was a more generalized challenge under Janus. The court granted, vacated, and remanded, GVR'd the case in light of Janus, giving a pretty strong indication that Janus will indeed have applicability. And in the wake of that, I know there's been at least one other case, again, out of Oregon filed challenging the integrated bar fees there. So I think you'll see that. Obviously, another area I think that there's some speculation on is whether or not there'll be a reevaluation of some of the student activity fee cases. I think that because of the limited fora that's created there, there's a bit of a distinction between that line of cases and the bar cases, but I think there's very likely to be a challenge in that context as
Yeah, I agree with Robert. The North Dakota case is Fleck versus Welch, and the challenge was brought obviously prior to Janus, and the claim was because the attorney had to affirmatively opt out of paying that portion of the bar dues that was being used for political activity. The claim was that was unconstitutional, that attorneys should be, that the default should be you just pay that portion that goes to regulation, and you should have to affirmatively opt in. Well, prior to Janus, that under Chicago Teachers Union versus Hudson, that requirement of affirmatively opting out was constitutional. And the Court of Appeals for the Eighth Circuit, in a decision in 2017, dismissed, rejected the claim. And that's a decision that this past December, the Supreme Court vacated and remanded for reconsideration in light of Janus. I agree with Robert. I think that will be the next domino to fall. Also in the area of public employee free speech rights, I think the Janus court essentially limited Garcetti versus Sabalos to its facts in terms of Garcetti will now only apply when the employee is speaking as an agent of the governmental employer. And the court has greatly expanded what is considered in the employment context to be issues of public concern. There's an excellent law student note that was just published in the Northwestern University Law Review that suggests, in the Pickering versus Board of Education, its progeny line of cases, that whereas previously lower courts, when employees were speaking about their wages and working conditions, their claims were dismissed as not being speech on a matter of public concern. Now, in light of Janus, the student note argues, that will be speech on a matter of public concern. Public employers will not be able to get rid of those cases on summary judgment, because we'll then be into the second stage balancing process of the employer's interest as an employer and the employee's interest in free speech. So yeah, Janus has opened up an amazing amount of areas where it's going to take years for this to settle down. I suspect Robert and I agree on that.
We have time for a couple of questions. We have microphone. If folks want to just come up to the microphone, sir, right there, if you want to start, that'd be great. Just a quick reminder, a question is a statement or a sentence that may have a couple of dependent clauses. That's fine, but it should end with a question, often indicated by an upward inflection or something else, a response from one of the panelists. But please, if we could have a couple of brief questions for our panelists, that'd be great.
I appreciate the definition. I've had to do it myself. In light of the majority's acceptance that collective bargaining is inherently political, and following up on Professor Mallon's statement, is there now a fundamental constitutional right under the First Amendment for public sector employees to engage in collective bargaining?
I'll take it.
Sure.
Sure. So, it's sort of interesting. There isn't Canada.
Actually, I wanted Mr. Wall to answer the question.
Okay, Robert.
Well, it is an interesting question. It goes to whether or not something constitutes political speech doesn't go to whether or not, and whether or not you have a right to speak does not go to whether or not an individual has an obligation to listen. So if you take a look, for instance, in our exclusive representation case, our claim is not that, in fact, the state has a duty to negotiate with our client. Our claim is that you cannot force our client to speak through an agent with whom she disagrees. And that's a very different claim. In fact, if you look at the old Minnesota board case, there the Supreme Court, in fact, denied the claim that you can force the government to listen. And whether or not it's on a question of political concern or not, I don't think changes that particular calculus. So in that case, I would think that the fact that it is a matter of public concern does not change, the ability to collectively bargain involves listening, and I don't think that you can compel that on the government agency.
Yeah. So the two Supreme Court decisions that are relevant here are Smith versus Arkansas Highway Employees Union and the Knight case that Robert just referenced. So the Knight case involved a kind of the attack that Robert's bringing for that professor in Maine, where these meet and confer sessions that were established by statute, where there was an exclusive bargaining representative, the exclusive bargaining representative controlled who would participate in them, and of course restricted it to union members. The Supreme Court found no constitutional problem there on two grounds. One, these meet and confer sessions were not a public forum, but two, as Robert said, the government, you have a right to speak, but you don't have a right to be listened to. The government can talk to whoever it wants. And the converse of that was a Smith case where a union member wanted to be represented by his union in his employer's internal grievance procedure, and the employer refused to allow it. And the Supreme Court says, yeah, you can speak, but the government can decide not to listen to you. If you get past that in these attacks on exclusive representation, and I read Robert's cert petition, and I don't buy it. I don't think you can get past that without dislodging those. If you dislodge those two decisions, yeah, I think that could open the way for a claim that, you know, a group of employees acting through a representative have a right to meet with their governmental employer and to confer, maybe not to collectively bargain, but to confer. I would refer you to the Supreme Court of Canada's decision in Ontario versus Fraser versus Ontario, which essentially held that under the Canadian Charter of Rights and Freedom.
I would just offer one clarification to your point, since you suggested that the claims in Knight were similar to ours. Knight neither briefed nor raised the claims with regard to compelled speech and association, which is the core and really only claims we raised. So those cases are different in kind, and I would argue the Supreme Court really didn't even decide that particular question. They decided the separate question of whether or not they could be compelled to, in fact, listen in the meet and confer context.
Time for one more question?
Yes, I'm unusual here because I worked under a fair share agreement for years. My biggest complaint against AFSCME was the discrimination against the fair share fee payers. I had to opt out every year. I was sold over to the union without any chance to opt out on day one. And also, I acknowledged their right to represent me, and they wouldn't let me vote on the contract. Another reason, I was a professional engineer, and I belonged to a professional engineering organization. And another complaint against the union was my professional engineering organization, dues are X, amount available to claims of federal tax deduction is Y. They told you up ahead, right at the moment you paid the dues, what was deductible for federal tax purposes and what was lobbying / undeductible.
Question?
How do you eliminate the discrimination that I suffered, but this was 15 or so years ago?
Well, I'm not familiar with the law on contract ratification in Ohio. I do know in Massachusetts, prior to Janus, fee payers did have a statutory right to vote on contract ratification. I'm just not familiar with Ohio.
Well, hopefully we've all enjoyed our discussion with Mr. Alves and Professor Mann. Please join me in thanking them. Thank you for your representation. If you need to submit a CLE form, Patty should be outside and can take those forms for those of you seeking CLE credit. Again, thank you all for coming.